Before we begin our next panel, it is my honor and privilege to introduce the President of the Moldova Constitution Court, Domnica Manole. If Domnica could come to the stage, please, who will just present a few brief comments. Domnica?
Here. Here. Eu prima?
Da. Da. Buenos días a todos. Constituye para mí una gran satisfacción poder moderar este debate sobre la independencia judicial en el sistema europeo. Creo que en una fase puramente introductoria del debate que se va a producir ahora, y rogaría a las sucesivas ponencias el cumplimiento exacto de los términos, de los ámbitos temporales para propiciar el buen orden de toda la organización, creo que hay que delimitar dos grandes perspectivas a modo de introducción en los sistemas europeos y en la jurisprudencia europea. En primer lugar, la referencia clara al artículo 6 del Convenio Europeo de Derechos Humanos. En el año 1950, la Convención de Derechos Humanos puso de manifiesto la necesidad de un juicio equitativo ante un tribunal independiente e imparcial dentro de un plazo razonable con las debidas garantías y resolviendo fundamentalmente los problemas que en el ámbito de las relaciones jurídico-privadas o en la actuación relativa a las actuaciones penales configuraba la esencia del juez legal, del juez natural. Algo que después el sistema constitucional español, en su artículo 24, reconoce diferenciando la tutela judicial efectiva como garantía sustantiva materializada en el acceso a la jurisdicción, la respuesta a la pretensión, los recursos legales procedentes, la proscripción de la indefensión y las garantías procesales constitucionalizadas, el derecho de audiencia, defensa, no confesarse culpable, derecho a un proceso público con las debidas garantías, derecho a un juicio justo dentro de un plazo razonable y respetando el derecho a la presunción de inocencia. La jurisprudencia del Tribunal Europeo de Derechos Humanos, que se produce a partir de la década de los años 50, va propiciando en numerosos supuestos, no voy aquí a hacer una relación exhaustiva, pero sí poner de manifiesto como en determinados casos, el caso Campbell, el caso Pirsac, más recientes, incluso afectando al sistema español, como en el caso Vera, en el caso Otegi, etcétera, se va configurando un cuerpo de doctrina que el Tribunal Constitucional Español ha ido asumiendo y aplicando por la vía del artículo 10.2 de nuestro sistema constitucional. Los tratados y convenios internacionales ratificados por España forman parte de nuestro ordenamiento jurídico y contribuyen al entendimiento del contenido de las normas. Por consiguiente, hay una primera frontera y un primer ámbito que a mí me gustaría subrayar, que es la actuación en todo tiempo del Tribunal Europeo de Derechos Humanos, propiciando esa defensa del juez legal, del juez natural. Y en segundo lugar, no me gustaría dejar de subrayar la segunda línea, que es la jurisprudencia interpretativa del Tribunal de Justicia de la Unión Europea, un tribunal que en sus inicios era ya tribunal constitucional por su contenido y por su ámbito competencial. Evidentemente, aquí damos campo al artículo 2 del Tratado Fundacional, el Tratado de Lisboa, que recoge los principios de la libertad, de la justicia, de la igualdad, los valores que inspiran las tradiciones constitucionales comunes de los distintos Estados miembros de la Unión Europea. Me gustaría subrayar cómo más recientemente, sobre todo examinando la jurisprudencia del Tribunal de Justicia de la Unión Europea a partir de 1995 y sobre todo fundamentalmente a partir del año 2015 y siguientes, se han ido estableciendo unas pautas fundamentales. Asuntos como en el año 2018, limitación de retribuciones a los vocales o consejeros del Tribunal de Cuentas en Portugal. Asuntos como limitación de edad de jubilación a los jueces polacos. Asuntos más recientes sobre orden europea de detención en relación con la actuación de la Fiscalía. Forman un cuerpo de doctrina que permite constatar que esa independencia ha de interpretarse en un doble sentido. Por una parte, como garantía institucional del Poder Judicial, inherente a la condición del Poder Judicial como tal poder ejercido por jueces que juzgan y ejecutan lo juzgado. Y, en segundo lugar, incidiendo en el estatuto orgánico del juez, en donde una de las perspectivas fundamentales es la imparcialidad. Imparcialidad que tanto la jurisprudencia del Tribunal Europeo como la del Tribunal de Justicia de la Unión Europea han insistido en dos perspectivas. La imparcialidad subjetiva, es decir, que el juez no se vea en su fuero interno mediatizado en el ámbito de la decisión, y la imparcialidad objetiva, preservando el interés objetivo del proceso a la hora de marcar su resolución. No quiero invadir más este momento temporal. Creo que deben ser los respectivos ponentes los que desarrollen los ámbitos que van a ser objeto de reflexión, y por mi parte solo me queda pues agradecer a todos el enorme esfuerzo que supone en este momento la asistencia a esta reunión en forma de mesa redonda. Voy a dar la palabra seguidamente al primero de los intervinientes en este ámbito para que desarrolle precisamente el contenido de su intervención. Me refiero al presidente del Tribunal Supremo de Eslovenia, cuando quiera.
Thank you very much. And dear President Cremades and distinguished authorities, I'm grateful for this opportunity that I have this possibility to discuss with you the question of independence of judiciary. It is a question which could be assessed and discussed from very different aspects. One of these is international level, another one is national level. But regarding the limited time which is now available for this discussion, I will be concentrated on the national level in Slovenia and to present some recent developments which are connected with the relations between three branches of government, because this question is very, if not the most important question when we talk about the independence of the judiciary. And at the beginning, I will stress that our constitutional and legal provisions regarding independence of judiciary are quite on the high level, so there is no problem, but problem could be at the level how these provisions are understood and enforced, and this is then maybe a problem of legal culture in a certain country, also in our country. And I will first start with a constatation that in a democratic state system, the division of power into three independent branches, legislative, executive, and judicial, is one of the basic starting conditions. And when we talk about the relation with the executive branch, I have to stress that recently we have a problem with the executive branch because we follow constant attacks against judiciary, against decisions which are adopted in the judicial branch. And for example, there was a statement of the highest representative of the executive branch of power, the Prime Minister, who 1 year ago made a public statement about the illegitimacy of judges in our country, describing them as heirs of the previous communist system of the previous state. Nevertheless, that all judges of the current judicial system in Republic of Slovenia were elected in the National Assembly, which represents the representatives elected by the people at general secret parliamentary elections. Of course, this statement of the Prime Minister shouldn't remain without an answer of the judiciary, and so I, as the President of the Supreme Court, protested to the President of the Republic of Slovenia against such an attitude of the executive branch. And with the President of the Republic, we agreed that we organize a public confrontation between the representatives of all three branches of government on relations between them, on the acceptable ways of communication among each other, and on the importance of respectful relations between them. Notwithstanding the fact that very different views on these relations were expressed at this meeting, the general public also had the opportunity to get acquainted with the contents that define the competences of each branch of government and understand the reasons for their relative independence. Another question was in relation with the legislative branch, because it was adopted by the Slovenian Parliament, National Assembly, in 2019, an act where it was stated that the Parliamentary Commission will inquire the political responsibility of public officers, including judges who were, according to this act, supposed to participate in the preparation and implementation of political and criminal prosecution against the former mayor of one of the cities in our country and a member of the second house of the Slovenian parliament. At the end, the Constitutional Court adopted a decision in which the Constitutional Court annulled this act of the Parliament. And as a conclusion of all these situations, I would like to say that it is obvious that it is not enough that the constitutional and legal provisions of the judiciary are perfect, but it is necessary also how these provisions are executed. And on the other hand, it is a need for constant vigilance of the judiciary, of judges, to be very aware what is happening around their branch. Thank you.
Muchísimas gracias. Tiene la palabra la presidenta del Tribunal Constitucional de Moldavia.
Thank you. Dear participants, colleagues, dear audience, in today's panel, I will talk to you about the case of the Constitutional Court of the Republic of Moldova. I will start with an introduction, and then my colleague, the Secretary General of the Constitutional Court of Moldova, will continue the presentation that we have prepared for you. As regards the independence of the judiciary, and in particular, the independence of the constitutional courts, perhaps too much has been said and written. The topic has a different meaning when you are one of the involved actors. With your permission, we would like to go beyond of an abstract presentation and to tell you about the concrete situation of the Constitutional Court of Moldova.
Recently, the Constitutional Court of Moldova underwent challenges worthy of the analysis of researchers in the field of judicial independence in transitional societies. With the departures of a political regime in Moldova in 2019, and with the coming of other parties to power, the entire composition of the Constitutional Court was changed. However, the alliance of the new parties that came to power did not last long. The dissolution of the governing alliance meant, for the Constitutional Court of Moldova, a busier docket. It is important to note that in the Republic of Moldova, a single member of parliament may lodge applications with the court requesting it to interpret the constitution or to declare a law unconstitutional. Thus, one of the parties that initially formed the alliance was left alone in power, and at the beginning of 2020, the government of the Republic of Moldova initiated procedures for signing an agreement with the Russian Federation regarding the granting of a financial loan of 200 million euros for the Republic of Moldova. After its signing, the agreement had to be ratified in the parliament. The ratification law was challenged before the Constitutional Court. The court considered that the procedure for concluding the agreement had been vitiated. The court noted that several provisions of this agreement were unclear, unforeseeable, and contrary to the national economic interests of the Republic of Moldova. However, in the run-up to the ruling, the court and its judges became the target of political and media attacks. Moreover, senior state officials, including the head of state at the time, issued statements likely to discredit the constitutional judges. They argued that, depending on certain rulings, the court would become politically captured and used in the usurpation of state power and will have to bear the consequences. This was the first major challenge for the court's independence in its new composition. Later, at the beginning of this year, and after the election of another president of the Republic at the end of last year, negotiations for the appointment of a new government took place. The political negotiations did not lead to any positive results, as the government has not been formed for 3 months, as the Constitution states. The Constitution also requires that the dissolution of the Parliament in case of failure to form a government. An application was lodged with the court to note that the circumstances justifying the dissolution of Parliament were met. The court delivered an advisory opinion which allowed the dissolution of the Parliament. However, the Parliament of Moldova declared the state of emergency during that period in connection with COVID-19 pandemic. The court was requested to declare the Parliament's decision on instituting the state of emergency unconstitutional. The court subsequently declared this decision unconstitutional as it limited fundamental rights without providing reasons in accordance with the standard of proportionality. Between the date of delivery of the advisory opinion dissolving the Parliament and the date of the decision of Parliament on instituting the state of emergency was declared unconstitutional, the Constitutional Court, and especially its president, Ms. Domnica Manole, was subjected to new attacks. This time, the attacks took an official form because they were done through the parliamentary majority. That is, through a majority that was directly interested in postponing the dissolution of the parliament as far as possible. On 23rd April of the current year, the parliament adopted two decisions. The first one concerned Ms. Manole's dismissal from the position of judge of the Constitutional Court. In the Republic of Moldova, the parliament, the government, and the Superior Council of Magistracy each appoint 2 out of 6 judges of the Constitutional Court of Moldova. In 2019, Ms. Manole was appointed to the position of constitutional judge by the parliament. In 2021, the parliamentary majority tried to revoke her mandate, although neither the Constitution nor the special laws allow such practices. The second decision of the Parliament concerned the appointment of a new constitutional judge to replace Ms. Manole. An unprecedented fact in history of the Constitutional Court has been the vast support of the international community. Mr. Gianni Buchicchio, the President of the Venice Commission, Mr. Charles Michel, the President of the European Council, Ms. Ursula von der Leyen, the President of the European Commission, Mr. Josep Borrell, the High Representative of the EU for Foreign Affairs and Security Policy, Mr. Valer Dorneanu, the President of the Constitutional Court of Romania, and the Department of State of the United States of America came with immediate reactions. They all condemned the missteps of the Parliament of the Republic of Moldova. The decisions of Ms. Manole, the decisions of Parliament in question were subsequently declared unconstitutional by the court. Ms. Manole also participated at the adjudication of the case with the consent of the plenary of the Constitutional Court after a request for her recusal was dismissed. These attacks on the independence of the court were unjustified, unpleasant, and unexpected, but the court managed to face them all observing the Constitution. The court guaranteed the supremacy of the Constitution. The court has shown that the judges are above any manipulation or intimidation. Pressures of any kind on the constitutional judges is unacceptable in a democratic state based on the rule of law. We remain firmly convinced and dedicated to continue to fulfill our constitutional duties with honor and dignity. Thank you very much indeed.
Thank you.
Muchísimas gracias. Tiene la palabra el presidente del Tribunal Constitucional de Andorra, don José Guardia Canela. Cuando quieras.
Muchas gracias, querido moderador, excelentísimo señor presidente del Tribunal Constitucional de España, señor presidente de la World Jurist Association y auténtica alma de este congreso y de las distintas opening sections que se han ido celebrando, distinguidos miembros de este panel y del relativo a América, algunos de los cuales reencuentro después de reuniones de la Conferencia Iberoamericana de Justicia Constitucional, de la Asociación de Cortes Constitucionales Francófonas y de otros ámbitos como la Conferencia de Tribunales Constitucionales Europeos y otros encuentros en el marco de la Comisión de Venecia, así como de la Conferencia Permanente de Academias Jurídicas Iberoamericanas, alguna de cuyas sesiones abiertas como esta he tenido también ocasión de conectarme telemáticamente. Expreso mi agradecimiento por haber sido invitado a participar en este acto en mi condición de presidente del Tribunal Constitucional de Andorra y por permitirme exponer la independencia del Poder Judicial en nuestro pequeño país en el marco de esta sesión. No puedo, sin embargo, dejar pasar esta oportunidad sin referirme, aunque sea brevemente, pero de todo corazón, al merecido homenaje que se tributa a la Justice Ginsburg, y para hacerlo recordando las dos oportunidades que tuve de tratarla en Barcelona gracias a mis buenos amigos Antonio García Padilla, con una participación muy destacada en este congreso, y al recordado Ramón Mullerat Balmaña, que nos dejó hace unos cuantos años. La Justice Ginsburg vino a Barcelona por primera vez en los primeros días de julio de 1996. Justo antes de salir hacia aquí, suscribió uno de los fallos más famosos al que se refirieron en la sesión de ayer, en el que ordenó al Instituto Militar de Virginia, de los más antiguos institutos militares de Estados Unidos, incluir a las mujeres como cadetes en las mismas condiciones que los varones. Se incorporó por 3 semanas al programa de verano que la Universidad de Puerto Rico y la Universidad de Barcelona llevaban a cabo Y, como en su día, también contamos con la presencia de otros jueces del Tribunal Supremo de Estados Unidos, como Antonin Scalia y Stephen Breyer. Durante su estancia en la ciudad, la Justice Ginsburg se integró en la comunidad jurídica, en actividades del Colegio de Abogados, en la Escuela Judicial, en conversaciones con pequeños grupos en los hogares de juristas catalanes que tuvo ocasión de visitar, y allí pude tratarlo. 10 años después, en 2006, la Justice volvió a Barcelona a la conmemoración de los 10 años del programa, volvió a integrarse en el mundo del derecho y de la cultura de la ciudad, y allí nos mostró también, como se dijo ayer, su gran pasión por la música. Ya entrando en materia, voy a decir que la independencia del Poder Judicial y su consiguiente imparcialidad constituye uno de los elementos esenciales, si no el más esencial, de todo Estado de Derecho. Hay que insistir en que el Estado de Derecho es aquel en el que no solo rige el imperio de la ley, sino en el que se respetan y promueven los derechos humanos y las libertades fundamentales, y entre ellos, de un modo destacado, el derecho a la jurisdicción, es decir, el derecho a una tutela judicial efectiva que comprenda esencialmente el derecho a un proceso justo, sustanciado por un tribunal independiente, imparcial y predeterminado por la ley, que ha de dictar una decisión plenamente fundamentada. La última Constitución andorrana tuvo la oportunidad de ya poder recoger en su texto algunas de las normas fundamentales que se habían recogido en el Convenio Europeo aprobado en el Tratado de Roma de 1950. Y así se proclama que se reconoce el derecho a la jurisdicción, a obtener de esta una decisión fundamentada en derecho y a un proceso debido, sustanciado por un tribunal imparcial predeterminado por la ley. También en otro artículo se dice que en nombre del pueblo andorrano la justicia es administrada exclusivamente por jueces independientes, inamovibles y en el ámbito de sus funciones jurisdiccionales sometidos solo a la Constitución y a las leyes. Igualmente, en otro artículo, el Consejo Superior de la Justicia, el equivalente a los consejos de la magistratura o del Poder Judicial, como órgano de representación, gobierno y administración de la organización judicial, vela por la independencia y el buen funcionamiento de la justicia. Dado el escaso tiempo del que dispongo, me referiré más específicamente a partir de ahora al Tribunal Constitucional, uno de los órganos judiciales al que más exigible es la independencia y que con demasiada frecuencia debe de hacerla valer ante ataques directos o velados contra ella. Respecto del Tribunal Constitucional, su ley cualificada, equivalente a las leyes orgánicas, ya alerta en la exposición de motivos contra la posible politización de su papel y, en su consecuencia, adopta una serie de disposiciones. Es importante la proclamación de estos principios, pero no es suficiente. Demasiado a menudo vemos en esta vieja, querida y entrañable Europa cómo determinados tribunales, también los constitucionales, sufren ataques a su independencia y en ocasiones, lo que todavía es más lamentable, abdican de su independencia para someterse a otros poderes. Los ejemplos son tan conocidos que no necesitan especificación. Quiero terminar exponiendo algunos principios, actitudes y comportamientos vigentes en nuestro pequeño Estado, que me parece favorecen la independencia del Tribunal Constitucional de Andorra. Lo hago consciente de que se trata de unas microrrealidades, pero que son susceptibles de convertirse en algo más grande, como las pequeñas semillas pueden llegar a desarrollar árboles frondosos. Quiero con ello simplemente hacerme eco de aquel deseo que hago mío, que decía el jurista clásico, de que es bueno que se pueda decir de alguien que serit arbores que alteri seculo prosint. Para ser magistrado del Tribunal Constitucional en Andorra no es imprescindible la nacionalidad andorrana, si bien con el nombramiento se obtiene esta nacionalidad pro tempore. Habitualmente los magistrados tienen nacionalidad española o francesa, que son los sistemas jurídicos más conectados con el andorrano. Actualmente el tribunal está compuesto por 2 juristas españoles y 2 franceses, y a lo largo de sus más de 27 años de existencia, solo un magistrado tenía la nacionalidad andorrana de origen. Se pensó que de esta forma se contribuía a la independencia e imparcialidad del tribunal y, sinceramente, creo que el resultado ha sido positivo y puede dar lugar a meditar más sobre ello. Los magistrados han de ser personas de reconocida experiencia jurídica o institucional. No es imprescindible la profesionalidad jurídica. Incluso en este momento, uno de los magistrados franceses tiene esta experiencia institucional, pero no la jurídica. El nombramiento se celebra por un magistrado por cada uno de los dos copríncipes y los dos siguientes por el Consejo General o Parlamento de Andorra. Los magistrados son inamovibles, disponen de una congrua remuneración, elemento también importante para garantizar su independencia, y no pueden ser objeto de insinuaciones amenazantes ni de estímulos para el futuro. Cesan automáticamente, y esto también me parece un elemento relevante, al cumplir el periodo para el que fueron nombrados, 8 años sin posibilidad de reelección inmediata. El tribunal sigue funcionando con solo 3 miembros en el momento del cese automático de uno de ellos. Es el órgano que ha de nombrar el sustituto quien asume las consecuencias de no ejercer su función con el carácter inmediato que le es exigible. El sistema de elección, por la razón expuesta de que se elige un solo magistrado por decisión personal o por mayoría de las 3/5 partes, no permite la cuotalización de los nombramientos, aspecto que se considera muy positivo entre nosotros, como es negativo en otras circunstancias. La ley cualificada del Tribunal Constitucional, en su preámbulo, explicita la voluntad de limitar los efectos políticos del papel del tribunal y para ello establece, primero, la autovinculación del tribunal a sus precedentes, excepto en supuestos excepcionales necesarios de una especial motivación. Segundo, la necesidad general de motivación de todas sus decisiones. La aplicación de los mandatos expresos de la Constitución y la prohibición de las denominadas sentencias interpretativas, la creación de un régimen disciplinario interno, la determinación de los efectos de las sentencias y otras resoluciones, la prohibición de realizar juicios de oportunidad política y de dirigir censuras, felicitaciones o recomendaciones a los otros poderes públicos. El Tribunal Constitucional de Andorra funciona con un riguroso sistema colegial. Se proclama el secreto de las deliberaciones y de la votación. Las decisiones son per curiam, afectan estrictamente al órgano en su conjunto. No se admiten votos particulares. En caso de empate, no decide el presidente, sino el ponente. El cargo de presidente no se obtiene por elección, sino por turno rotatorio de 2 años entre los diversos magistrados. Podría citar otras realidades, pero desbordaría excesivamente el tiempo conferido. Y termino ya. La independencia judicial es factor esencial para que una democracia, para que un auténtico Estado de Derecho pueda realizarse. Esa independencia ha de ser externa e interna, respecto de los otros órganos del Estado y respecto de los particulares. No puede perderse por ninguna razón, ni por miedo a consecuencias negativas, ni por afán de ofertas positivas o de recompensaciones futuras. No podemos ser parciales ni podemos ser dependientes. Probablemente en más de una ocasión habremos de ser independientes también de nosotros mismos, de nuestros sentimientos, de nuestras emociones, de nuestra ideología. Muchas gracias por su atención.
Muchísimas gracias al presidente del Tribunal Constitucional de Andorra. Tiene la palabra el presidente del Tribunal Supremo Administrativo de Finlandia.
Thank you, Mr. Chairman. Distinguished colleagues, señoras y señores, buenos días. It's a true privilege to be able to share some thoughts about the independence of courts in the EU with the participants of this prestigious conference. So I'm not concentrating in the Finnish relations, but fortunately we don't have experiences just like our Moldovan friends. I will discuss 3 points of view from whom the courts should be independent of, and why is independence so important, and how can it be safeguarded. In parliamentary democracies, the rule of law is a principle of paramount importance. Just like President Javier Cremades put it rightly yesterday, it is the bedrock of our pluralistic societies. And also, according to the EU treaty, I quote, "The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities." Hence, illiberal democracy is not the model for Europe. One of the basic ingredients of the rule of law is the independence of judiciary and individual judges. My friend Damijan from the Slovenian Supreme Court already referred to the separation of powers doctrine. And it means that legality and the supremacy of the law presuppose that all, and especially courts and judges, are under the obligation to obey the law. They are not independent in relation to Parliament as legislator in abstracto, but legislators must not intervene in concrete court cases. Parliament is free to enact law given that human rights and other constitutional constraints are respected. And here, the judge's role is crucial to control the constitutionality and safeguarding of human rights. Independence means that judges are free from external pressure. They should not be subject to political influence and manipulation, not under the thumb of the government, as Ruth Bader Ginsburg has crystallized. Rights of people, companies, organizations provided by the Constitution and other laws can be realized only if effective legal protection is guaranteed. Protection may be needed against other individuals, but may be more often against authorities, be it tax authorities, environmental permit authorities, authorities applying social security law, immigration law, etc. Independent courts enable those seeking for justice to get what they are entitled to under the law. And if the executive could influence the courts, the rights would be illusory. That is why the independence of the courts is so important. So the independence, it's not guaranteed for the sake of the courts themselves, but it's ultimately for the sake of citizens seeking for justice. Recently, there have been numerous regrettable examples of violations on the independence of courts in Europe. Rule of law is fragile, as Patricia Lee Rifo said yesterday. Case law of the Court of Justice of the European Union and the European Court of Human Rights reveal, for instance, that legislation has been amended to lower the compulsory retirement age of judges retroactively. Chief Justices' terms of office have been terminated prematurely. Organizational rearrangements within the judiciary have taken place, and appointment procedures of judges have been violated. These warning examples make it necessary to ask how independence of judiciary can be safeguarded. In my opinion, one of the key answers is to foster a solid legal culture in which all the central societal actors, as well as the ordinary citizens, recognize the significance of the rule of law. We also need robust legal provisions partly at the level of the Constitution, protecting the basic guarantees of independence so that they cannot be amended by simple parliamentary majority. We should ponder thoroughly if, for instance, basic provisions concerning compulsory retirement age, number of justices at the supreme instances, and appointment procedures could be sealed in the Constitution. Thank you.
Muchísimas gracias al presidente del Tribunal Supremo Administrativo de Finlandia. Tiene la palabra la presidenta del Tribunal Constitucional de Letonia.
Thank you, Mr. Chairman. Ladies and gentlemen, still good morning. Under the Latvian Constitution, judges shall be independent and subject only to the law. As a sitting president of the Constitutional Court, and before a judge in this jurisdiction for a decade, I have witnessed various ways in which the judicial independence was challenged and sometimes made vulnerable. I will share with you some remarks concerning the judiciary independence in Latvia. First of all, I should elaborate on a series of cases which gave the opportunity for the Constitutional Court to guarantee the financial independence of Latvian judiciary. Second, I'd like to insist on some of the current challenges on the judiciary, the pressures from the politicians and some groups in the society. First of all, speaking about the allocation of financial resources to the judiciary, I should add that in Europe we share an approach called in German Verfassungsorgan Treue, loyalty of constitutional bodies, meaning that the constitutional bodies on an equal importance should show mutual respect and loyalty toward each other. It is in the light of these preliminary considerations that I shall elaborate a slightly greater detail the problematics of the financial independence of Latvian judiciary. The cases were brought, 3 cases. The court in quite different circumstances. The first time the court had to review the reduction of the judges' remuneration happened in times of a harsh economic crisis, which almost led the government to default on payments. Reviewing the case, we were in agreement with my colleagues that to examine the constitutionality of judges' remuneration means to verify first whether the judges' work is appropriately remunerated so as to guarantee the independence of the judiciary, and second, whether the change in the level of salary affects the separation of powers. More precisely, it means to verify whether the judge's remuneration is fairly correlated with the ones received by officials from the rest of constitutional bodies, members of the parliament and members of the government. Some 5 years later, when the remuneration of judges was challenged before the Constitutional Court for the second time, I was the judge rapporteur and mine was responsibility to submit the draft of the judgment. Preparing the case, I found that at least one such case has been almost in every European country. It didn't matter whether I was looking for the so-called new democracies, such as Lithuania, Slovenia, Poland, or countries with considerable experience of democratic legal culture and implementation of the principle of the separation of powers, such as Germany. I also found that this question equally affects the southern and the northern Europe, as illustrates the well-known case Juízes Portugueses decided before the European Court of Justice. All this visible outlines the existence of the common approach in Europe. There is no independent judiciary without financial independence. Now about pressures on the judiciary. How do you react as a judge to those who show their outrage against the courts for the decisions they take. In Latvia, the Constitutional Court has recently decided on 3 types of cases that continues to excite polarized attitudes in the society. These cases concern, first, the territorial reform by which, in essence, the government intended to merge the smallest municipalities with the aim of greater efficiency of administration. Second, cases where the court had to decide on the same-sex couples living in a family. Latvia being one of the few European countries who doesn't recognize any form of legal union for the same-sex couples. Finally, the court decided whether the intended ratification of the Istanbul Convention of Preventing and Combating Violence against women and domestic violence is in conformity with the Constitution. These decisions coincided with appointment a new judge to our court. The final decision on the nomination belongs to the parliament. And for the first time, the Latvian public heard from parliament discussions that was less about the professional guarantees or professional qualities of the judge candidates, but rather the ideological attitude about policy to the same-sex couples. In the same line, a recent opinion poll conducted among all the judges, including questions such as, do you suffer from a pressure from the politicians, media, parties, of a case or general public? The majority of judges in Latvia participating and answered in the affirmative. We are living in very dangerous time, and I have thought very much what we can do to ensure judges' independence. First of all, we should get support from society. It's our only possibility to get support from society. But if we need to get support from society, we should educate at first the society. And the Latvian Constitutional Court started with education of school kids about Constitution. Every year we make a competition, and school kids draw about Constitution or write essays about Constitution. Younger kids are drawing, and teenagers are writing essays about human rights, equality, human dignity, constitutional values, and the teachers should support their children. And it means that teachers too should learn about Constitution to support children. And after every competition, the best works are published. This book goes to schools, libraries, and you can't understand because essays are in Latvian language. But you can see the drawing about equality. This is a 10 or 11 years old kid, and she or he thinks about equality and draw about equality. And I think it's way how we can get support from society, just to work with new generation and believe that the new generation will be cleverer, stronger on rule of law than this generation. Thank you very much.
Muchísimas gracias. Después de estas brillantes intervenciones en la mesa que me ha tocado moderar, quiero poner de manifiesto, como se ha puesto también de relieve en las precedentes intervenciones llenas de sabiduría, llenas de experiencia y insertadas dentro de lo que es la función judicial, el extraordinario valor que la independencia judicial es inherente a nuestros respectivos estados de derecho. La asunción de los principios constitucionales comunes, el respeto a las tradiciones constitucionales de nuestros respectivos estados, la profundización en aspectos tan puntuales de la independencia como es el análisis minucioso con argumentación jurídica y resoluciones suficientemente motivadas, es lo que en definitiva fortalece en el día a día de nuestros quehaceres profesionales la independencia judicial. Por consiguiente, yo hago fervientes votos en esta reunión para que esa labor de estudio, esa labor de deliberación profunda, responda precisamente a una exigencia de nuestra ciudadanía cuando pide de nosotros certeza y seguridad jurídica, certeza y seguridad que ha de proyectarse en el Estado de Derecho democrático al resolver asuntos que afectan a la defensa de los derechos y las libertades fundamentales, y en el Estado social del derecho, cuando lo que se trata fundamentalmente es dar respuesta a las exigencias del Estado prestacional, a los principios rectores de política social y económica que sin duda han de informar la legislación positiva, la actuación de los poderes públicos y sin duda también la práctica judicial. Muchísimas gracias a todos.
I would like to thank our eminent jurists for this incredibly interesting conversation about the key issues surrounding the pressures on the judiciary in Europe and possible solutions. I loved the book, even though I can't read it, because the education starts with the very young, Thank you all very much for your very insightful comments regarding the judiciary and the pressures on the judiciary in Europe. I'd like to now welcome to the stage the Chief Justice of the Supreme Court of Canada, who will lead the next panel on the independence of the judiciary in the Americas.